All right. Hello, everyone, and welcome to Hiring and Firing Hot Candidates, Not Hot Water, brought to you by Davison, Eastman, Munoz, and Payon. Um, I'd also like to thank our partners, including our presenters, Citizens Bank, Focus New Jersey, Manufacturing Counts, Minding Your Business, NJBIA Support Center, the New Jersey Business Magazine, and Planet Hollywood. I'm sorry, Planet New Jersey. I apologize.
I was like,
I'm
wow.
Wayne Stobbs, and I have the pleasure of being the Chief Business Relations Officer for the New Jersey Business and Industry Association. Our presenters today are employment attorneys Brian Shabarik and Nicole Croddick from the law firm is Davison, Eastman, Munoz, and Payon. Both Brian and Nicole specialize in employment law. They service clients throughout New Jersey and beyond and are based out of the firm's Freehold, New Jersey office. Today, we're going to hear about processes and procedures and best practices when it comes to hiring and firing challenges and some interesting real life stories of Brian and Nicole's employment law adventures. Just a few housekeeping matters before we get started. Today's webinar is being recorded and we will be emailed to you along with today's presentation, so be on the lookout for that. But I'd also like to draw your attention to the question tab. Brian and Nicole would be happy to take your questions, so get them in as they come to you via the question chat box. With that said, and without any further ado, I'd now like to turn it over to my colleagues, Brian and Nicole. Please take us away.
Thank you so much. Just putting the PowerPoint on. Give me 1 second, and then we will put it in presenter mode. There you go. I'm going to start. I'm Nicole Croddick, and I'm going to start with, starting with what I always say is the pre-offer phase. And, there's a lot of regulations and rules that you have to consider when going over this. And the important aspect of this, what I usually tell our clients is that in the pre-offer phase, there's very few areas of inquiry that you can get into as far as, what comes out on the application and what you're being asked in an interview. And a lot of the pre-offer questions relate to, how qualified and how well they think you'll do the job. Like, what is your educational background? What certificates do you have? Things like that. What is your experience? And once you give someone a conditional job offer, that's when we launch the person, not literally, but we're launching into the post-offer phase where you can ask a lot more information of the potential candidate. And that's where we're getting into things like background checks, maybe drug tests, proficiency exams, and things like that. So pre-offer, very limited, very focused on, the job, your skills, your trainings, and the post-offer is a lot more broad. So we start with just a little bit of information on the Opportunity to Compete Act. That's a law that was passed in New Jersey. It's pretty, it's based on, an individual's right to not be, so to speak, judged on their criminal history. And the reason it's nicknamed sort of ban the box is that it took off in a lot of the applications in New Jersey, the box that used to say, check this if you've ever been convicted of a crime. So the idea is that we're giving individuals who have had past criminal convictions, the opportunity to compete in the job market in a lawful way. So that again is the ban the box. So why that's relevant is, again, you cannot have someone answer that question on a job application as well as during an interview. I would like to note that when it comes to this pre-offer phase, anything that is not able to be asked on a job application is also not able to be asked in an interview. Once we have the initial interview, then we can get, as I mentioned, into a lot more information. We also have to
Nicole,
be mindful.
we have a question. If,
Yes.
if somebody during that process shares information with you, like, a prior arrest with marijuana or something along those lines, how do we handle that?
That's a great question, and that would be a voluntary disclosure. So what it does happen, someone might be like, hey, I was caught with a joint in my car in college, or I got in a bar fight. I just want to throw it out there. If someone volunteers, you're able to inquire about that at this pre-offer phase. And again, it's going to come out likely in the background check as well, which is in the post-offer phase. So that is an exception if someone volunteers the information. Just be aware, though, it's going to be up to you as the employer to prove that it was actually volunteered and you didn't ask it.
It's also interesting that you mentioned marijuana or cannabis because it's been legalized and you can't take an adverse action against someone in a job offer or in hiring solely because of the fact that they consume cannabis. So that's something to always keep in mind.
That's true too. So it makes the layers a little easier, but a little more complex. So good question. So thank you. Also, when it comes to credit checks, we have to follow the New Jersey Fair Credit Reporting Act, which pretty much mirrors the federal Fair Credit Reporting Act. And that most of these requirements are again things that you can look into in the post-offer phase. But the idea, especially with Fair Credit Reporting Act, is giving the candidate or the potential candidate notice and getting their consent to look into that. Same with a background check, so on and so forth. The clean slate law, that is something that is a law in New Jersey where if someone has a criminal conviction that was expunged, that is not something that can be considered in the post-offer phase, and employers cannot take adverse action against that. And of course, the New Jersey social media privacy law, which is a hot topic, also says that potential employers cannot require you to give them their passwords to their social media for them to kind of do a dig deep. So some of the background checks that many employers do get into in this post-offer phase, if that makes sense, that second world, are the criminal background checks, the credit score checks. Again, if it's relevant to the job that's being done, that's an important. And of course, if you gave notice and consent, employment verification, like where did this person work? What were the dates of employment? Note that when it comes to employment verification, you are not allowed to ask someone about their past salary history. That is something that is, prohibited in New Jersey. But when you're verifying employment, usually the former employer would say something like, yes, they worked as an accountant here from 2020 to 2023 or something like that, as well as
Excuse me,
education.
Nicole.
Yes.
We do have another question, and Brian, both of you may be able to help with this. How does it work when you are a manufacturer and I have a no drug policy when it comes to cannabis? I know it is difficult to tell when it is consumed on a test, but we cannot have employees operating machines while under the influence.
There's a couple of issues there. First and foremost, just because cannabis was legalized and just because you could also have a medical marijuana card, which came before the legalization of just recreational marijuana, you're still allowed to operate a drug-free workplace. You're still allowed to prohibit the use of cannabis in the workplace. Now, if it's manufacturing and it's involved in transportation and you're getting involved in CDL requirements or you have federal contracts, then you can have additional prohibitions because it's still illegal under federal law. And it gets very complicated because it's legal under state law, but not under federal law. But the short answer is you are absolutely allowed to prohibit the use of cannabis in your workplace, regardless of if someone has a medical card or if someone is utilizing it. You can't take an adverse employment action against someone solely because they take it. And then the other issue is, if someone is involved in an accident or someone appears impaired, at that point, you have two people corroborate what they've observed and you can get them drug tested. But if Nicole, if you want to
and that's where too, we like to analogize it to alcohol. Just because it's legal, it doesn't mean you can come to work drunk, right? And start similar to that. You can't be impaired. So yes, you absolutely can. And obviously many places still have a substance-free workplace. Does that make sense?
Yeah.
All right. So again, you as the employer are going to, verify the employment past employment, educational verification, drug screening, and keeping in mind, though, you could not take adverse action just because someone, tested positive for having marijuana in their system, which stays in your system usually 28 to 30 days. And we were actually talking about that before getting on screen. Many employers are not even testing unless they're in working in a safety sensitive position or with a federal contract or something, because if it just tests positive for marijuana, there's not much they can do in a post-offer pre-employment test. And
also there was litigation involving Walmart where they received a job offer contingent on a drug test, came back positive for cannabis. The job offer was rescinded. He filed suit that was removed to federal court, and his case was dismissed because you are not permitted to take an adverse employment action against an employee for or solely for the use of cannabis. However, the cannabis law is still developing, and in the statutory regulations, there were no provisions for that individual to pursue a claim on their own. The court had said either the legislation has to be amended or the Cannabis Regulatory Commission would have to pursue it. That case is up on appeal, and we are monitoring it and watching it because they basically left that employee without a remedy when the law is very clear. You cannot take an adverse employment action against someone solely because they have cannabis in their system or because they use cannabis. It's different if they come to work impaired, as we were saying.
Yeah.
So.
Yeah, and that's something to keep an eye out for. So what are some of the best practices? Obviously, anytime you're dealing with even your hiring procedure, make sure you have a good, solid policy in place that is, compliant with the various laws. Also, make sure that you are clear on the scope of the background checks. You get consent, you give notice to potential candidates. Make sure too, any sensitive information you might get, such as, someone's criminal background check or the results of a drug test, that you have a process for handling that information, for keeping it secure, keeping access to that limited. And of course, you always want to make sure there's documentation that follows the policies and procedures that you will follow. And of course, there's individuals who are tasked with carrying those policies out, and they're trained on doing it appropriately. So, when it comes to picking out, for example, who will do a background check, just a quick note, when this ban the box law became law in New Jersey in 2015, a lot of people said, well, at the end of the day, I'm probably going to come to the same result, even if I could, like if someone said, yes, I was convicted of armed robbery 10 years ago, they said, I'm probably not going to hire this person, whether they checked it off on the application or it came as a result of a background check. However, at the end of the day, the idea is that the results may still come. Your choice might still be the same, whether it's done in the pre-offer or post-offer phase. However, there are situations where people say, yes, although this person has this background, we're going to, we see that they might have been rehabilitated or educated, and we think they'd be a good hire. So keep in mind when you choose your background check provider, you want to make sure that they are compliant, that they are accurate, that they have a fairly reasonable turnaround time, that they're transparent, because a lot of times if someone does have a background that we're going to use to not hire them, you do have to give the potential candidate that information and give them the opportunity to dispute it, because there are errors sometimes. And of course, going off of that, we have to make sure that we have the proper procedures in place and the potential candidate knows exactly what we're checking, gives us consent, they have notice, and they have an opportunity to dispute the results. Because as I mentioned, candidates do have rights even before they're hired when it comes to this. And that's why keep in mind that pre and post offer world. Another aspect of once you do actually hire someone, our recommendation is always to put a probationary period in place. 90 days is usually what employers use. However, it can be up to you. I kind of call it the get out of jail free card. And it's kind of like a speed dating situation where you have 90 days to say, hey, well, this employee be a good fit for the culture and for doing the job within our organization? And on the flip side, will we be a good sort of home for this employee? The reason why we call it the get out of free jail card is we can, at that point during the probationary period, which is usually before things like benefits are able to be taken by that employee, we have an opportunity where if there seems to be, you know, someone that is not a good fit, we're able to more easily terminate that person, saying, yes, you're still in your probation period. We don't think this will be a good fit. So again, it allows both sides to sort of have a trial run, so to speak, and it is much easier to terminate an employee during that probationary period. And I always recommend, by the way, a lot of times people say, hey, I want to get rid of this person, and it's day like 89 of a 90-day probationary period. My suggestion is, if the writing's on the wall early on, take action sooner rather than later. Also, substance abuse, we talked a little bit about that. You know, make sure you do have workplace drug policies, including, if you'd like, a substance-free workplace policy in place. Drug testing, again, you're going to want to give consent, and it's also going to be part of a policy, whether it be pre-employment or as a result of someone coming to work impaired. And just because someone has a medical marijuana card, as per the various laws like the Compassionate Use of Medical Marijuana Act, does not mean that they could actually come to work high or impaired. It just means, you know, they have the right to, similar again to alcohol, they have the right to take marijuana as part of medical treatment. When it comes to employer obligations and workplace rights, regulations, and the like, just because someone is in a safety sensitive position, it again doesn't mean that their rights are limited as far as, you know, taking adverse action for someone solely for using marijuana, again, unless it's part of a federal contract or someone's a federal employee. And as we mentioned earlier, the impairment in the workplace is still a situation that we can prohibit. And that's where, you know, again, you have the right, and we would recommend putting in place policies where if you reasonably suspect, and by the way, that's reasonable suspicion, not absolute certainty, that someone is under the influence, you are able to test them and then decide what you're going to do from there. And, you know, one other note on that, there is a good form that was put out by the state of New Jersey and the relevant agency that does give you a lot of guidance, or some guidance. It's the best guidance we have for you know, reasonable suspicion testing and some of the factors to consider.
That's the Cannabis Regulatory Commission form, because they were charged with establishing credentials for WIREs, or workplace impairment recognition experts, but those guidelines have not been established yet. But that form that is on their website basically has preferably a manager and another employee corroborate the signs and symptoms of someone being impaired, and has a whole list of items that you can complete, circle, fill out. And also, when Nicole was discussing the Compassionate Medical Marijuana Act and the medical use, there is a Supreme Court decision, Wild versus Carriage Funeral Home, where a funeral director was involved in an auto accident but was not at fault in any way, shape, or form, and disclosed that he had a medical marijuana card to the hospital, so that when he had his blood draw, it would come up positive. The funeral home ultimately terminated him, saying, we can't deal with having a funeral director utilizing marijuana. And the courts had said that he could pursue a claim under the law against discrimination for disability discrimination, because they didn't have any evidence that this impaired his ability to work. He never showed up to work impaired. The accident wasn't his fault. And they had an obligation, which we'll talk about, to engage in the interactive process, because if he required a reasonable accommodation for that use, they would have had to. So that's why you always have to be careful, just because someone is utilizing marijuana, we have to see, well, was that the cause of the accident, or was there impairment in the workplace that affected their work?
Yeah, and that's why with that the form that the Cannabis Regulatory Commission drafted, it does have, as Brian said, all these factors that you can check off, and it's really the best that we have right now until we
Right.
get further guidance. So I would definitely check that out. If you
Yeah,
haven't seen
excuse me, can you please, we just got a request, can you please repeat the website that the forms are on?
Yes, it's on the Cannabis Regulatory Commission website. If you click that on, because that has all the guidelines for dispensaries, for cannabis, the new cannabis law, and on there's drop-down menus for employment, and on that form they have a 2-page sheet giving some guidance to employers,
Factors and
right?
stuff.
And then there's a 2-page sheet for the employers to fill out, but it's on the CRC website, or Cannabis Regulatory Commission website, and they actually are a public agency and have meetings that are available to the public to watch on Zoom. But again, it's the CRC, or Cannabis Regulatory Commission site, and if you put that in, it'll pop up.
And again, it's a New Jersey agency.
Thank you.
Okay, so Nicole took you through the hiring process. I will talk about the best practices for terminating a problematic employee, an employee who's had performance-based issues. Nicole deals a lot with the training, with the onboarding, with the hiring, and I deal with a lot of the litigation and the fallout. So I want to discuss best practices in terminating an employee, because there's always issues that arise. The first issue is, I always say, document, document, document. If you have an employee who's having performance-based issues, they have to be documented, whether it's in a memo form, whether it's in your performance evaluations. And it's very important that you do those performance evaluations either on a yearly basis or every 6 months, because I can't tell you how many times I've had a case under the law against discrimination where someone claimed that they were terminated based on discriminatory reasons, based upon their age or their race or their gender or their ethnicity, or they were subjected to a hostile work environment, or they made a claim of harassment and the company retaliated by terminating them. Then, and the way the law against discrimination works is that employee comes forward and has to make a prima facie case to say, I'm over the age of 40. I was clearly terminated for age discrimination, or whatever the protected class is. The ball shifts back to the employer's court to demonstrate a legitimate business justification for the action that was taken. I cannot tell you how many times I've gotten the personnel file, and every single performance review just says meets or exceeds expectations. There's no comments. I have nothing to document that this employee was actually terminated for performance-based issues. The burden ultimately shifts back to the employee to show that the employer's stated reason is a pretext, and their stated reason to show that it was performance-based is false, because they can't keep their story straight. They don't have the documentation in order. And then it's up to a jury to decide. And employers, unfortunately, litigation is very expensive. And my job is to keep my clients out of court. But employers always have an inherent bias against them by juries, because you're the big bad employer. So it is extremely important to document any performance-based issues. And I say you have to be honest, because the employee is entitled to honest feedback, because there's always room for improvement. There is no employee that I've ever seen that should get excellent on every single aspect of a performance review, because there's always going to be something that they could improve upon. And I know it is very hard to be face-to-face and give an employee poor or negative feedback, but they're entitled to that, because then they have an opportunity to improve that aspect, or maybe they need more training in a certain aspect. And then you have it documented. It has to go in the personnel file. And a lot of times it's recommended you have the employee sign an acknowledgement that they got their performance review. Employees, a lot of times, if they don't like what they see on it, says, well, I don't agree with it. It's just an acknowledgement that they got the review. So,
Excuse me, Brian,
yes,
we do have a question. Is there
Okay.
the 90-day probationary period?
Right.
Do the same rules apply? I mean,
it's much easier to say, because a lot of times we'll put it in the employee handbook or we'll put it in the offer letter, to say that things did not work out. It was the first 90 days, because most performance reviews are done within the first 6 months or a year. But we say that there's that feeling out period that you could realize this person's never going to cut it. It's going to be a much, much harder claim for someone to pursue a wrongful termination claim under the law against discrimination or SEPA, which I'll talk about, the whistleblower, if they are terminated within that 90-day probationary period. But it should be made clear to that employee that there is a 90-day probationary period, and whether it's in the handbook that they're going to sign an acknowledgement that they received it, or it's in the offer letter, it's another layer of protection to the company.
Yes. And that's
Thank
why I
you.
say I call it the get out of jail free card. And just one note on we've seen a lot of people with performance, their annual reviews that are amazing on paper. But yet again, when we speak to the employer or the manager, they're like, they're terrible. They don't do their job. They come to work late, yet they have all exceeding expectations. So we always say, make sure your narrative about this person would match the file. So we want them to be, the same thing and not look like there's a disconnect between the actual person and the documentation that supports that. So be honest.
And everything should go in the personnel file. Again, you have to have constructive criticism of the employee. And again, if you're having issues with the employee before it comes time for performance reviews, then prepare a memo, whether it's a memo for the file, it's a memo to communicate with the employee. Just make sure it's documented and it's in the file. And as we said, you make sure that there's a clear role set forth with the duties. A lot of times there's duties in writing, which is preferable, because then they know what their expectations are. There's certainly management who is available to provide leadership and goals, and that if you have productivity issues and they're not it's like if they're incentive based, if they have to meet certain percentage of sales, make sure that's documented. And sometimes the better place, if you incentivize it and they get bonuses or commissions, there's that carrot at the end where they're going to want to exceed expectations, not just meet them. The other issue is, if you're really having a problematic employee, you can always consider what's called a performance improvement plan. Performance improvement plans set forth very specific and detailed goals that have to be met within a specified time period, whether it's 30 days, 60 days, 90 days. Otherwise, and it'll have the infamous language that we always say, you will be subject to further disciplinary action up to and including termination. Because if you're having significant serious problems with the employee, and it could be a long-time employee who maybe they've just been there too long, and you say that you're not meeting your goals, this is what I expect to see from you. We are going to meet every 2 weeks or every week and make sure you are meeting those goals. But by the way, if you don't meet these expectations within that 60-day time frame or whatever time frame you set, then they know there's no misunderstanding, that it should never be a surprise when someone's terminated. But also that protects you. Yes.
We have 2 questions. Let me just get in there. So one is, should a 90-day probationary review be done in addition to a 6-month review?
Yeah, I mean, I think that, well, first of all, I would recommend not day 90, as I said. I would recommend like day, 60 or 45, because really the writing's usually on the wall within the first 6 weeks. So that is something you can do. Again, just make sure that it's consistently followed, like any policy, which, is important, and that it is done in an honest way. But to Brian's point, I think the performance evaluation during a probationary period is certainly not, it's good to have, but it's not as critical as the performance evaluation after the expiration of the probationary period.
Right. I would say it certainly
can help.
Wouldn't hurt. It can help. But certainly someone who's terminated in the first 90 days as an attorney, I think most attorneys would be less inclined to take a case too, because the person was there for such a short period of
Yes.
time. Though some of the tools at your disposal too, if you're terminating, say, a longtime employee or employee who's been there for some time, I always suggest giving them a separation agreement or severance package, because you're getting a full release of claims, and we prepare these documents all the time. So you are never going to have to hear from this individual of any potential claims in the future. They're waiving any potential employment related claims under the sun, including the law against discrimination, which is what employers are fearful of because they are so expensive to defend, or whistleblower
Retaliation, yeah.
cases with under retaliation. But those severance agreements basically will have specific provisions in there, which will set forth that you're going to pay them additional compensation beyond their last date of employment. You're not required to pay them anything beyond their last date of employment in the state of New Jersey, unless it's in an employment contract, which very few employees in New Jersey have, unless they're high-level employees or CEOs, CFOs. And then those employment contracts will usually spell out, if you're terminated without cause, you're going to get X amount as a severance. If you're terminated with cause, here's what with cause is. It's embezzlement, it's fraud, it's this. You will not get a severance. Other than that, you're generally not required to give severance. Now, if you're a large corporation that has a severance plan in place or policy in your handbook, you would have similar type language and would even say you might get 1 week per year of service or 2 weeks per year of service. And a lot of times it's always negotiable too, because they're signing a release of claims. And in the severance agreement, you have terms in there too that, they're going to keep anything that you gave them confidential. It's not the time to try to sneak a non-compete agreement, which we'll talk about in there. But if they were subjected to a non-compete, a non-solicitation agreement, you reiterate that those are still in full force and effect. You have a non-disparagement clause in there that they're not going to say anything negative about the company. They are not going to post anything negative about the company. And if that happens, or if they do, they're going to have to refund that severance money. And so these are specific protections for the employer. And as I said, I've seen it where companies do try to sneak in all of a sudden an egregious non-compete policy that you're not going to work anywhere in the United States in a competitive industry, right? And they're not. First, it's not going to be enforceable, and second of all, that non-compete should have been done at the time of employment, or if it's felt that you need it during the course of employment, you can always do it during their employment, because there has to be consideration, and at that time, the consideration is their continued employment. If you want to continue to work here, you have to sign this non-solicitation agreement that you're not going to steal our clients, that you're going to protect our proprietary information, our client base, our secret sauce. But just be cautious with non-competes right now, because the FTC issued, as you have sure have seen in the newspapers, a nationwide ban that was to go into effect September 4th. However, almost immediately after the issuance of those regulations, several lawsuits were filed in federal court, and there were divergent opinions issued from Texas and Pennsylvania. However, shortly before the deadline of September 4th, the Texas federal court issued a nationwide injunction saying that the FTC exceeded their authority. This took an act of Congress. They did not have the authority to issue a nationwide ban, and that non-competes should continue to be regulated by each of the states. Now, some states in the United States do ban them. Some states have specific regulations. New Jersey, just like most states, looks at the reasonableness of the non-compete as far as time, space, geography. But right now, we have to monitor that too, as we always do in employment, because that was the district court. That can go up on appeal to the circuit court, and ultimately it could end up in the Supreme Court. But right now, there's a halt on that nationwide ban, but everyone is seeing the writing on the wall. And there's a number of states that are implementing either bans or very strict restrictions. And it's because over the years, non-competes probably have been abused, because you don't need a low-level employee to non-compete. It's more for someone who has access to the client base that deals with the clients. And you can't prohibit competition just for the sake of competition. You can't do that. But you have a right to protect your client base.
You and Nicole may have covered some of this, but we do have another question.
Okay.
And it is, New Jersey is an at-will state in terms of employment. How does that work to support termination of an employee or against the employer?
You want-
I always, yeah, New Jersey absolutely is an at-will employment state. And I always say that means that you can sever the relationship for any reason, either side, unless there's a contract of employment and then there's specific terms for termination. But just because you're an at-will state does not mean that you're immune from a potential claim of discrimination, because the caveat is I can terminate you because I don't like the color of your tie. I can't terminate you because I think that you're getting up there in age and I want to bring in a younger kid, or because I have an issue with your race, religion, gender,
Sexual orientation.
right, sexual
Yeah.
orientation is another one, or any protected class. So yes, New Jersey is absolutely an at-will state, but you have to exercise caution because employees now are savvy and they read the newspaper, they see the jury verdicts, they can try to craft a claim and say, well, I was terminated because of my age. I was terminated because of my gender or my race, or I believe that there was some illegalities going on or some violation of public policy, and I reported that to a supervisor, or I reported that to a state, and the response was to terminate me, which was retaliation under the Whistleblower Act. So, yes, we're absolutely an at-will state, but in order to protect yourself from these claims, you need to document it.
And that's why I always say at-will employment is the governing principle for, I think, every state but Montana. So if you live in Montana, you're okay. However, the biggest dissolution of at-will employment is wrongful termination claims. So that weakens the doctrine of at-will employment. So anyway, and just one quick note, if I may, on performance improvement plans. A lot of times people they have a bad taste in their mouth if they're subject to it. My two suggestions are, you don't have to call it that, even though it might in substance be that. And in my opinion, and I think Brian agrees, it's a win-win. If they improve, guess what? You have an improved employee. And if they don't improve, which goes back to what he was saying about documentation, that now you have a good record to say, hey, we tried to work with this person. We put a lot of time, effort, energy, resources into it, and they just couldn't step up to the plate. So
Right.
just a note on that.
And the performance improvement plan as well is a signal or notice to the employee. And a lot of employees nowadays will know,
Freak out.
well, I don't think I'm going to meet this. Maybe it's time to start looking for another
Yes.
position. So it's almost giving them a 90-day window to find something, because obviously it's always easier to find another position while you're gainfully employed.
Exactly.
So we talked about the severance agreements, which is usually a good idea, not for a 90-day probationary employee unless there's a specific reason, but for more the long-term employee or employee who's been there for a year, 2 or 3. Specifically, if someone's been there 20, 25 years, then we usually would recommend some type of severance agreement so that you don't ever have to deal with getting a threatening letter from a law firm and then contacting counsel. So I had mentioned, yes, it's an at-will state, but the caveat is there's the Conscientious Employee Protection Act. That's the whistleblower statute, where employees are not expected to be lawyers. They're not expected to know the specific laws, but they have to have a good faith belief that there's some illegality or violation of public policy that my employer is engaging in, and I'm reporting it, or I'm threatening to report it, or I report it to a state agency or to a supervisor. Again, they do not have to be lawyers and know every detail of the law, but the key is there has to be a good faith basis. There's cases out there where a nurse went and reported her nursing home or agency to the state, but she knew that they weren't bound by those regulations. She was referring to a different set of regulations that didn't apply. So that she didn't have a good faith belief in any illegalities. But in a number of instances, if an employee reports some type of illegalities or some type of violation that they feel that's got to be addressed by HR. It can't be swept under the rug. And certainly the worst thing an employer could do is immediately terminate that person, because then now you're involved in retaliation. And those are the words that attorneys are fearful of, because jurors can't latch on to the word retaliation and award big dollars. Same thing with the law against discrimination. I hear employees say all the time, I'm subject to a hostile work environment, but they don't really know what that means. A hostile work environment has to be conduct that's so severe and pervasive that no reasonable person could endure it. And the word is reasonable, not an overly sensitive person. And it has to be directed at a protected class, which would include race, national origin, sexual orientation, sex. Pregnancy, is a big one because you have to be careful when someone comes to an interview and they're showing and they're pregnant, or someone is pregnant. That it has to be against a protect us. I hear time and time again that, well, they changed my supervisor, they changed my manager, and I have a micromanager for a boss. He's creating a hostile work environment for me, or he's watching everything I do. That's not a hostile work environment. I always ask, well, has there been any inappropriate comments made directed at any protected class? Has there been any instances of that? I had a case years ago with an individual who was older that they wanted to retire, and they put a cartoon with an old crow in his cubicle. Well, that's potentially age discrimination. And of course, his personnel file for 35 years had all great reviews, and they said it was performance-based. You don't want to be put in that situation because these cases do get expensive.
Yeah.
So,
One note, when it comes to hostile work environment, I always tell people it is not performance related, because a lot of people say, like, similar to Brian, oh, my work environment's hostile. And I'll say, like, what's happening? And they're like, oh, well, I was told I have to come to work on time. And if I have a project that's due like November 1st, guess what? I have to turn it in by November 1st. And I was like, that is actually doing your job and
Right.
being held to performance standards, not hostile work environment.
But you don't want to be caught in a situation defending a case where they say, when are we getting rid of the old crow? And
Yes.
and they claim that it was performance-based, but his performance reviews were excellent. So
Yes.
We touched upon this too. Reasonable accommodation is when someone comes forward, they don't have to use the word reasonable accommodation, but they come forward and say, hey, I have a reason that I need some type of job accommodation. And job accommodation, it could be because maybe they're undergoing treatment for cancer. Maybe they have a physical limitation. And the law is very clear that if someone comes forward and says that I have an issue, a physical limitation, a mental limitation, that I require some type of accommodation, you can't just sweep that under the rug either. You have to engage in what's called the interactive process and sit down with the employee and discuss what are the potential accommodations or reasonable accommodations you're looking for. And I always say employers don't have to acquiesce or agree to every single accommodation that an employee asks for. And not coming to work is not an accommodation. Not working is not an accommodation. But if it's something as simple as maybe they need to adjust their hours once or twice a week to get treatment, they come in an hour early and leave an hour early, or maybe they require a bigger screen, or maybe they require a different type of mouse, and it's something that doesn't create an undue burden on the employer's operations. It's something that has to be considered.
Yeah. I always say too, like, a reasonable accommodation, the process is the most important piece of it, so that we can find one that works for the disability, which PS might require someone to have to submit medical documentation that, of course, you're going to want to safeguard, because we're not experts in all sorts of disabilities, as well as keep the person qualified, meaning able to do the essential functions of their job, which that comes down to the importance of, this could be a whole other day, of having up-to-date, accurate job descriptions where the duties are listed of what people are expected to do as far as the again, essential functions. You can even list them as essential functions, which I call, in layman's terms, the heart or the meat and potatoes of your job. So that's why that's something that should be constantly updated. And reasonable today may not be reasonable tomorrow. That's another thing. So you can actually, I recommend a lot of times with this, have sort of check-in periods or expiration dates. If someone is given a reasonable accommodation, let's say they are working from home for a 3-month period while they undergo chemotherapy, after those 3 months it expires, and it doesn't mean we can't extend, but it has to be sort of looked at within certain periods of time. So it's not never ending. So
and one of the hot topics in accommodations, or reasonable accommodations, is the employee asks to work remotely, because as we learned from COVID, employees were able to work remotely in most instances. So now sometimes when employees were told to come back to work, some employees got comfortable working remotely and would say, well, I need a reasonable accommodation to work from home. Well, you're allowed to not delve into their medical history, but you're entitled to know what is the basis for
Sure.
your need for an accommodation. I've seen or heard where, well, I have childcare issues. That's not a basis to get a reasonable accommodation. But I need to work from home 1 day a week because I need to treat for cancer, as you said. That would be different. And if they can perform the essential functions of the job remotely, that's something that could be considered. Also, there's the new federal law, the Pregnant Workers Fairness Act. There's also the requirement that you provide lactation breaks,
That's
and
the pump
the
act.
breaks room is not to be in a bathroom, but I'll let Nicole might.
Yeah, no, I just briefly, these are federal laws. New Jersey kind of was already on this bandwagon, but it does give additional rights to pregnant and postpartum employees. And the essence of a lot of these new laws, like the Pregnancy Worker Fairness Act and the Pump Act, are that there are more robust obligations for employers to accommodate pregnant employees, as well as, employees that are nursing, again, giving them appropriate breaks to express breast milk, giving them an appropriate place to do that. And to the employee under the Pregnancy Workers Fairness Act, yes, if I work on a factory line, but I am 8 months pregnant, I might be able to get a couple extra breaks, or I might be able to sit down for part of my shift. Again, all considered reasonable accommodations associated with pregnancy and childbirth conditions.
Excuse me, we do have a question. What about religious reasonable accommodations?
Yeah, that became very hot, obviously, when there were requirements to take the COVID vaccine. Again, for religion and disability, those are the two sort of instances where there can be a reasonable accommodation. And what we did learn from that, which again, there's a lot of litigation currently surrounding that time period of the pandemic and after that individuals are able to be accommodated on what's called sincerely held religious beliefs. A lot of companies were saying, well, that's not a sincerely held religious belief. But the good thing is, we were saying from the beginning, don't question someone's sincerely held religious belief. Just go with it and then work on the process, the accommodation process, which is the same. It's an interactive process where, again, no, you don't need to get a letter saying, yes, they are a devout follower of avocadoism. I just make that up, but you know what I'm saying, like whatever it is.
But also it all depends on the industry you're in. If you're in a hospital setting or a doctor's office, it's different than if you're in an office, right? So.
But yeah, so that is another reason for reason, and these all should be written in your policies and procedures that yes, we will reasonably accommodate. An example of a common one is if someone has no PTO, yet they want to celebrate a religious holiday or observe, I should say, then an example of a reasonable accommodation could be, giving that person an unpaid day off. So
we get to a couple of just scenarios that we've seen. So in hypothetical one, it's Friday afternoon and the company decided we've had enough issues. We are ready to terminate Sally. But there's always the but that I get. Okay, what is the but? What is the issue? Well, Sally also raised a complaint of harassment against her supervisor in a hostile work environment 2 days ago, sent an email. What do we do?
Yeah, and that's where obviously, the optics would look like, we're terminating Sally because of performance reasons. And the way that I usually analyze those situations, because this happens all the time, and P.S., retaliation is the number one reason, fear of retaliation, of why employees, including managers of all, anyone of any level, are afraid to report wrongdoing in the workplace, is fear of retaliation, because it's a real thing and it happens at an alarming rate, usually the less obvious forms. However, in that situation, I always ask employers to analyze, are you really terminating or taking an adverse employment action against Sally because she's a whistleblower or because of a business reason? So, again, if there's performance issues that hopefully are documented, and, there's other situations where you're terminating Sally because of performance related issues, or she didn't successfully complete a performance improvement plan, that's different than saying, all right, Sally, who actually has been an excellent employee, you know, she has no performance issues. I understand at-will employment. However, you know, after being here for 25 years, she just filed a complaint against her boss for sexual harassment. Guess what? We're replacing her. We want to get rid of her. We want to shut her up. That then looks like retaliation. And so always ask yourself, is this adverse action that I'm taking against Sally or whoever it is being done for a business reason? Like, you know, a whistleblower that comes to work impaired, right? Maybe high, smelling like marijuana, acting like they're high, or is it being taken for in retaliation for them to, you know, opening their mouth or shining a light on wrongdoing that's happening here? And just as a PS, all of these laws came from the Enron cases, which if anyone is as young as myself, you'll remember the Enron cases, and that gives you a little bit of background. And I think the New Jersey law, the title of it, I always tell people, is the essence of what it stands for. We want to protect the conscientious employee. We'd rather them come forward with wrongdoing that's happening in our organization than being slapped with a lawsuit, or then by getting, you know, audited by some governmental agency, you know, without notice. So
employees are savvy nowadays too, so
Yes.
they see the writing on the wall, they get a performance improvement plan, or they see that there's performance issues. They'll try to craft a claim to say either I reported some illegalities, I'm a whistleblower protected under SEPA, or there's a hostile work environment, I was discriminated against, because they think that that will protect them. But as soon as someone says the words hostile work environment, or that, as Nicole alluded to, well, my manager sexually harassed me, that's a big red flag. And we ordinarily suggest that that be immediately investigated. Parties should be separated. There should be a prompt and thorough investigation done. Your handbooks should always have policies on harassment and how it is prohibited, and how to report any claims, and how to report if it's the direct supervisor who is engaged in the harassment, that you have alternative people to report to, and that there'll be no retaliation for making a good faith complaint of harassment, that it will be kept confidential, and it will be investigated. So ordinarily, unless there's an exigent circumstance or an immediate circumstance with that employee who you want to terminate today, but just filed a claim of harassment or hostile work environment, it's probably a good idea to do the investigation so that you documented that you did the investigation, you took the proper action, you separated the parties. If you find a violation of policy, you reprimanded, you're disciplined, you took whatever action against the employer, and then the employee, at least you've done the investigation. Whereas if you do nothing, then it's just going to appear that this was just retaliation because they filed that complaint. But whenever I hear those words, the first thing we do is say, you have to do an investigation. It has to be neutral. HR can do it. We can do it, or any law firm can do it. And again, the nature and how quickly it does really depends on how many witnesses, because Nicole does a lot of them, and we'll interview the complainant first to find out, are there any witnesses I have to talk to? And we'll speak to the target last when she has all the information. And the worst thing you can do is sometimes we get, well, I'm going to fire the manager. Well, then you didn't give them any due process, because we all know there's three sides to every story. You haven't heard their side of the story yet. So you have to be careful on that.
And one note on investigations, or a couple notes, because like I said, I've done hundreds of them all over the country, is that all you're trying to figure out, people like freak out by the word, is whether it's corroborated that a policy violation happened. So this is not like O.J. Simpson and beyond a reasonable doubt, like you're going to end up in jail. This is just whether it's more likely than not that ABC company's policy was violated. And a lot of times it comes down to like, who's more credible and why. So keep that in mind. And the report that's drafted at the end, which is very time consuming and, you know, really details all the steps you've taken, which Brian alluded to, is what's going to show, should something get to litigation. Yes, we took this complaint seriously. As soon as we heard about it, we launched this investigation. We talked to all these people. We looked at the, you know, the person's digital footprint. You know, we talk to the witnesses, et cetera, et cetera. So really important. But again, all we're trying to figure out is whether it's a violation of policy.
Right, and the Supreme Court years ago had weighed in on the importance of having a policy that you don't that's very clear to the employee, that you don't pay lip service, that you follow to. And it was Aguas versus State of New Jersey, which set forth a horrific set of circumstances of sexual harassment, but the employee never availed themselves of that complaint mechanism, never filed a complaint. So they were not able to pursue that claim. So that's why it's so important to have it detailed in your handbook, have the policy in place, and follow it.
And start in-house first before you don't go right to a lawyer.
Right.
Because again, that could be an affirmative defense, not to be too nerdy lawyer, but it's true.
Second hypothetical, and we're running short on time, but we'll be quick. Substance abuse. You have an employee who comes forward and says, I have a medical marijuana card, and during my break time, I want to go in one of the conference rooms and engage in taking the marijuana. Now, there's all different types of forms, but let's say they want to smoke it, and I have a medical marijuana card, so I need to take it. And I'm going to take it during work hours, or I'm going to go out on my lunch break and take it. What do you do?
Or gummies, whatever choice you choose. At the end of the day, as we mentioned, you still can prohibit that, because you still have the right to have a substance-free workplace. You still have the right to, obviously, keep in mind, safety is always paramount. That's where a lot of these substance-free workplace policies stem from. And of course, that is not a reasonable accommodation, because you can still say, you can't be impaired on the job, and you can't, marijuana card or not, you can't be impaired on the job, and we still endeavor to have a substance-free workplace.
Yeah. And then lastly, workplace romance. I can't tell you how many times I've had an place of employment with a consensual relationship that went south. As soon as the breakup occurs, there's going to be a claim of sexual harassment, and the employer didn't take action. And the employer then unfortunately gets put on the hook. And I've had it where the employer didn't even know anything about it until the 11th hour, took action, and still had suit brought against them because this consensual relationship went sour. And there's also a distinction whether it's a supervisor and a subordinate versus two-level employees who are at the same level. You should have policies in place that discourage it, but if an employee is in a relationship, they have to disclose that, they have to divulge that to the employer. And sometimes the employer can have them sign an acknowledgement they're in the consensual relationship.
A love contract,
right,
I like to call it.
as you want to say. So
yeah. And that's where too, a lot of times people, because Brian and I write a ton of policies, people say, oh, well, they can't get involved in my love life or whatever. Well, the whole essence of why a manager should not date a subordinate is because not that they're getting involved in your business, but rather it causes significant conflicts of interest for the people in the relationship and those around them. And anytime something good or bad happens surrounding that relationship, they're going to say, is it because they're dating the boss? Or because I'm not dating the boss, or is it because they actually did a good job? So the whole idea behind a lot of these policies is to come forward and not hide it, but rather disclose it. And in most cases, employers are just going to move people around, not fire you. A lot of people are like, oh, I don't want to tell them, but a lot of times they might move you to a different department, or just so there's not that consensual relationship. And one other thing is, once it's over, it's over. So don't think because you dated someone at work for 20 years and then you break up, you can't come forward if they still continue to pursue you, because then it goes from consensual to non-consensual. So
right, and you absolutely cannot have a supervisor that you become aware of involved in a consensual relationship with a subordinate. That's where you're just asking for trouble in that type of environment, because then you as the employer are now responsible for your supervisor that could be on the hook under the law against discrimination. So it's a good idea to put in your policy that that we understand it does happen. People spend more time at work than they do at home sometimes. So you have to disclose it, and then HR can consult with their legal counsel to take the proper action or proper course to protect the employer from any claims.
And that's why too, just one other note on that, when it comes to workplace romance, a lot of times with that imbalance of power, I've heard victims tell me, well, I had no choice. Like I wasn't going to go against the boss who kept pursuing me. So it also, you know, from an academic level shows that there's almost like a lack of knowing consent because they feel like, all right, if I say anything, I'm probably going to be fired. So.
Any other questions?
Wow.
Yeah.
Well, you really covered a lot there, Nicole and Brian, and there's so many topics that you brought up, you know, social media being an interesting one, obviously cannabis. So we appreciate your presentation. I appreciate your free flow conversation with our members and answering them as they come up. You know, I just would like to say that I've learned a couple of things here today that I now may need to call you about on a couple of things, but we appreciate your time. We appreciate everybody being here. And I just want to say thank you and have a good day. And we will be sending this out to you within a week. So on behalf of Brian and Nicole and myself here, Wayne at NJBIA, we just want to say thank you and have a great rest of your day. Thank you.
Thank you for helping us monitor the questions and organize this. So thank you. And thank you all for your participation in questions. It makes it much more engaging when there's people, you know, listening and taking in what we're saying. We know it was a lot. So thank you.
But thank you for listening to us.
Yes. All right. Have a good day.
Thank you, everybody. Bye-bye.
Bye.